Good evening. I'm Attorney Lawrence Berliner. I want to thank everybody who has registered for tonight's webinar. It's hard to believe this is our second year of Zoom webinars, but it is. Finding your voice as a parent. And we're trying to set the stage and meet the challenges of this school year. I'm Attorney Lawrence Berliner, and with me this evening is Jane Faherty, our co-host. And we have a special guest tonight, Allie Grafman, who's an advocate. She'll talk a little bit about herself. We are continuing to present these Zoom webinars because we're a community of concerned parents, advocates, and professionals, and we're still learning how to connect in order to get through these difficult times together. It's hard to believe we've been in this COVID-19 never land for almost 18 months. Maybe I keep saying there's light at the end of the tunnel, but we're not at the end of the tunnel. For the past year, we've been moderating a series of webinars to address these unprecedented times, the need to address the impact upon your child's special education journey. We have convened tonight to address many questions, and I want to thank all who have showed up and logged in tonight. The webinar is being recorded, and we will post it on YouTube for those who've registered, and that'll be on Eventbrite, and it's being streamed on that site. Before we begin, I do have a disclaimer. The webinar is being recorded, as I mentioned before. The information provided during the webinar does not constitute specific legal advice to you or your child and should not be relied upon. The webinar does not establish an attorney-client relationship with Attorney Lawrence Berliner, myself, or a client relationship with Jane Faherty or Allie Grafman. By signing up, you've agreed to receive information about future webinars and events from the Stamford Jewish Community Center and the Law Office of Lawrence Berliner. Please note this is a web format conducted by Zoom, which is a third-party provider, and it's not an agent or associated with the Stamford Jewish Community Center, Allie Grafman, and the Law Office of Lawrence Berliner. We have many questions, and we're trying to keep them general so all who are participating may benefit. We would prefer that your questions be placed in the Q&A format, not the chat format. The reason being, the chat format is part of the recording. So if you are concerned about maintaining your privacy and confidentiality as we are, we would prefer that you not use the chat feature. The question and answer feature is not part of the recording. So for those who have questions that are not already covered by our extensive list of questions, please use the Q&A format, which is at the bottom of your screen. We're going to go over several areas. Some of them have been influenced by the questions we received. And this is a continuation of the transition back to school. A year ago at this time, most of our children were either online, hybrid, and occasionally in school. This year, the mandate has changed to in-school attendance, which in of itself has raised questions. There are questions about parental observations that we've received. We'll get into that a little bit. We're always preparing for PPT meetings, school recovery and compensatory services, and starting a framework for collaboration and communication with your school. I had a couple of new items to mention before we get into Jane and Allie. There is a new IEP that's coming out next year for the 2022-23 school year. And we thought it might be a good time that all of us start to think about the changes to the IEP document itself. The State Department of Education has a lot of information. It's mostly for school district training purposes, but it's certainly available for parents and others as well. And you'll see in the chat format, we have the State Department of Education website available. The U.S. Department of Education has some publications on transition planning for the older students, usually around age 18 to 21, a little younger in some cases. There is also on the State Department of Education website a new parent guide to special education that's been updated after many, many years. Most people should have received the new version of the procedural safeguards by now. I think they were amended last April or May. And so if you don't have a brand new copy with an April or May date on it, make sure you do. And our U.S. Department of Education has released funding and made announcements with respect to an area of vital concern to me, because many of my clients and their parents are very much anxious about school, return to school. And they have a resource on the U.S. Department of Education website, ed.gov, supporting child, social, and student social, emotional, behavioral, mental health during the COVID-19 era. All of this is available, readily available on the State Department of Education website and the U.S. Department of Education website. So we have Jane Faherty, who is the director of JumpStart at the Stamford Jewish Community Center. She's also an educational advocate and consultant. And I will turn the webinar over to her, and she can discuss what is new, give a little background information, and then we will turn this over to Allie Grafman, who we're excited to announce that she has formed her own advocacy office, and she can just go into that.
Thank you, Larry. It's nice to be back again this evening, and we have an awful lot of questions that came in before this webinar, so we're going to enjoy answering those for you and with you. And then please continue to provide us with new questions as we go through. I can see we've already got a couple popped up now. So my background is my previous life as human resource manager for Ashley UK and Europe. And for the last 13, 14 years, I've been in early childhood education, and that's what my master's and specialty is. And in the last seven and a half years, I've been working at the Stamford JCC, supporting a program called JumpStart, where we exclusively support children with developmental disability, aged between 2 and 3. But I also help support community partnerships and relationships with different organizations such as Ableist and STAR, to name but a few. And through my work with the children and the programs that I support, I support them through advocacy in the public schools as well, when they transition and as they continue through the school districts. So I wear a number of different hats, but it's really great to be here this evening and to answer a variety of questions that we received tonight, all about IEPs, compensatory education to out-of-district placements and everything in between. So it's a real pleasure to be here again this evening, and lovely to have you with us, Allie.
Good evening, everybody. It's so nice to have you join us. And I'm looking forward to this webinar, and hopefully we'll get to the questions that everybody has asked. My background in special ed advocacy started 9 years ago. Before that, I was a public school special education teacher. And then for the last 10 years of my public school career, I was an administrator in special education, from a coordinator to a district administrator. So I come to advocacy with a perspective of the way the school thinks, and looking at how advocacy can help and support my clients through the navigating the steps along the process within the schools. So my perspective in education really comes into play with my advocacy services. Just recently, I separated from an advocacy agency, and I now have my own advocacy agency. The name of this is ABC Advocacy LLC, which translates to Advocacy Brings Change. I'm really excited. Look at my website, which is abcadvocacyllc.com. I'm really looking forward to the school year because it is a change from previous years now that we have in school, back to school, in-person learning has really been a focus for many of my clients, and it's certainly a change from last year. So we're going to continue the webinar, and hopefully, as I said, we'll get to the questions, all of the questions, and we'll go from there. So I'll turn it over back to you, Jane, and see if we can continue. Thank you.
Yeah, well, interestingly, we're all excited that this school year we're back in person. Most school districts, the kids are back in person. They might be wearing masks, but everybody seems to be back in person. But one of the first questions we received this evening was regarding still a virtual public school setting. So the question was to either of you, can you discuss what is sufficient services towards IEP goals in a virtual public school setting?
Attorney Berliner, do you want me to start with that, or would you like to?
I was going to say, Allie, you might have be closer to the ground with that, but I have a few comments.
Okay. So because we are back to in school, in person, I think just about all our districts here in Connecticut, there's no longer a mandate for remote. It's not mandated. However, that being said, there are situations where remote is going on, whether it is because of the student, may have to, because the student is certainly able to learn, but is not able to come to school for various reasons. So the idea here is that the public school is definitely responsible to meet the child's free appropriate public education. In other words, whatever the child's goals are, the school district, whether it's remote or in person, has to meet those specific goals and related services. So whatever the IEP reads, that's what the district needs to carry through. However, the key here is how the district does that. They have to meet the child's free appropriate public education. However, the way they do it, they may combine services. In other words, a special ed teacher and a speech pathologist may combine their services to be able to provide the appropriate services with speech and language and special education combined. So even though the related services and the special ed services are part of the remote learning, the school district is given variability and flexibility on how they meet the child's educational program. So that's probably what I have to say. Attorney Berliner, you can certainly add to that if you'd like.
The only couple of comments I'd add is the free appropriate public education, the FAPE standard that Allie talked about, has never been repealed. And there was a letter from Betsy DeVos, the US Department of Education secretary, back in, I believe it was March 2020, that made that clear. And that's whether you have a mandate for online instruction or not. The second thing I wanted to point out, there are many school districts, I'm up to about the number 5 or 6 that have offered online instruction for students. New Canaan, New Haven, Waterbury are 3 that just off the top of my head. There's a couple of more that I can't remember. And the bottom line is whether it's virtual, hybrid, in person, it's supposed to be appropriate. Now, the virtual instruction is different than homebound instruction. Homebound instruction is based upon a, quote, verified medical reason why a student cannot attend school, and the student will get an hour or 2 a day of instruction, whereas the virtual instruction should basically be very close, if not the entire school day.
The only thing that I would add too is that there are some providers, there are some specialists and related service providers within districts that are more comfortable with a virtual remote platform than others, as there are educators too. So sometimes it is worth, when trying to make sure that your child continues to receive the appropriate related services as detailed in the IEP, that you can also talk about maybe the comfort level or skills of some of those providers providing those skills, because in speaking to some educators in districts, some of them were very comfortable with the online virtual platform, whereas others were not. So it is okay to be honest and have a conversation about somebody's level of comfort and expertise with the virtual platform versus doing something in person, because teachers felt quite differently about it, as did some clinicians and providers in the districts as well. So this is a legal question, Lawrence. I'm going to direct it towards you. So what are a parent's legal rights if the school is not willing or intentionally not providing services as per the PPT?
Well, I think the individual might mean IEP. The PPT is the meeting, the IEP is the educational planning document. So if an IEP, an individual education plan, lists services, and I should also add that while we have many people coming from places other than Connecticut, our information is Connecticut focused. So if you're from New York, PPT meetings are CSE meetings. Some states, they call them IEP meetings. In Connecticut, we call them PPT meetings, but it's all about special education and the IEP. But back to the question, in Connecticut, on page 11 of the current IEP, there's a numerical tally of the services that a student should receive. How many academic service hours per day, per week, how many related service hours per day, per week, the location, who's responsible, a special ed teacher, regular ed teacher, paraprofessional, somebody else. And if the IEP is not being delivered as written, number one, you can certainly have a conversation or meeting, informal meeting with the school district and find out why. Say we have 5 hours a week listed, but my child's only getting 3 of those 5 hours. Could be a staffing problem, could be a misunderstanding. Maybe you're thinking in a 60-minute hour and the school district is thinking in a 45-minute hour or 42-minute, class period. So don't always assume the worst. But there are situations, and I've had it, and I'm sure Jane and Allie have well, where the IEP is not being delivered because they fail to hire the staff, or they're having staffing shortages, or they're sharing the staff with other students. And the IEP as written should be delivered. Now, you can go to a due process hearing and say, my child is being denied a free, appropriate public education. But there's another way to go as well. And the State Department of Education has an informal, not a due process hearing, complaint investigation procedure called the Complaint Resolution Procedure Complaint, otherwise known as a CRP complaint. This information is available on the State Department of Education website. ct.gov is the main website. You'll see in the chat room the specific Department of Education website is. So if you feel or believe that the IEP as written is not being delivered, have your meeting, consider a CRP complaint, and or if necessary, file a request for a due process hearing. Because the IEP can only be amended through a PPT meeting, and usually that's with parent input as part of the process. So the school should deliver the IEP as written and not do anything less.
Sure, Allie, this is something I come across quite often. I'm sure it's something that you come across fairly frequently too, with the IEP detailing a certain number of hours of related services, but the school districts not consistently, whether intentionally or unintentionally, delivering those services to the families. I always encourage families to keep a track of the services that are being provided on a weekly basis, who is delivering those services, and the areas that are being covered during that time, almost as a service log for themselves. and to also ask districts fairly frequently to provide their service logs as well. Do you have any other advice for parents, Allie, in terms of keeping a track of the number of hours of related services provided to their children?
One thing that I would add to that, Jane, is especially this year, there is a tremendous amount of shortage of staff, whether it be special ed teachers, school psychologists, social workers, speech pathologists, you can go on, and paraprofessionals. There's a huge shortage of paras across the state and probably other states as well. There's many reasons for that, but the basic thing here is that I have seen families come to me because their child is not getting the services because there's no staff in place. So my heart goes out to the public school because you understand their situation, but you have to be your own child's advocate. And to do that, you have to make sure that your child's rights are being observed and by the school. And so that really does require, in my opinion, collaboration with the school, and most likely going back to a PPT to see if the IEP can be served in a different way. Like I said before, through remote, maybe some of your child's pragmatic communication goals could be covered maybe by a school social worker or the special ed teacher. And that could be an interim situation until staff is there. But I do agree with Jane, document everything. And, you know, in the long and short of this, we may be talking about compensatory education for those services that are not being delivered. But right now, I think the best feeling that I have is to be flexible, try to work with the school as much as you can, unless you see your child really struggling because he or she is not getting those services, then you really have to act. And there's, you know, various levels of that, but certainly I think that right now the shortage has created many difficult times for both the families and the public school.
Yeah, one statistic I read over the summertime was one of the districts had a 60% deficit in terms of teaching staff, which is tremendous. I mean, that's such a huge loss of expertise and literally hands-on debts teaching the children within different districts. So it is a real problem. And when districts are saying they're short staffed, they're not just using that as an excuse. It actually is a genuine problem that is occurring. So just bear that in mind too.
Well, there's a lot of economic stimulus dollars that have flowed into Connecticut from Washington with the various economic stimulus packages. And there's somewhere between 40 and about 111 million brand new federal dollars, some of them specifically allocated for special education, some of them more general education purposes. So I would hope, I did speak to a special ed director last year when we were supposed to get 35 million new special ed dollars. And he said, it hasn't shown up in my district. So somewhere between Washington, Hartford, but not the local district. So we should be mindful of the fact that there are a lot more resources that are coming, that should be coming into Connecticut from Congress, economic stimulus package legislation, and that should be showing up as a way to alleviate some of the burden. We did have a question that was posted tonight about having a speech and language, I assume as an associate. If the IEP has a speech and language pathologist, which is the credentialed person delivering the services, that person should be delivering the services. But if the IEP says SLPA, speech and language associate, or a OTA, an occupational therapist associate, or a PTA, not that PTA, but physical therapist associate, you need to read the IEP very carefully. It might be on page 2 of the IEP, the PPT summary or recommendations, or it might be on page 11 of the IEP that lists the service implementers. That's why it's important to understand the IEP document itself. Even though it's changing next year, it's still in place right now and for the rest of this school year. And you should be aware of the lingo, the acronyms. So, okay.
Yeah, and one of the questions, I think that question related to particular practices within speech. So for example, there's prompt speech, there's different aids that you use for speech. So it's very important as well that if your IEP specifies a particular program, for example, a specific reading program, that you have or prompt speech, you have the right, the professional that is trained within that certification to deliver that service, because there's very explicit training that goes on, and quite often the training is over a long duration of time. So it's not something that somebody can pick up over a quick webinar for a few hours. Training with certain reading programs or speech prompt programs or using different techniques does require somebody with particular credentials and experience and training. So it is important to make sure that when you have that information in your IEP, that the right people are delivering some of those services and practices.
One of the comments in the chat is to make sure that the parent understands what's in the IEP. You know, this is not a document that's designed to create a barrier between the family and the school. It's basically an educational blueprint or roadmap that's supposed to give everybody some guidelines, the guardrails, so to speak, on how a child will spend their school day, their school week, their school year. And if you don't understand the IEP lingo, the acronyms, you know, then parents are not having effective and meaningful participation in the development of the IEP. You know, the language of the IEP should be usable, friendly, consumable on all levels. So you have a basic understanding of what services are being provided, what the strengths and weaknesses are of your child, how the weaknesses will be addressed through academic goals and objectives, through goals and objectives for the related services. And if you don't understand it, maybe you can take time outside of the PPT meeting to set up a separate meeting with the principal, the special ed director, a related service provider, wherever you're not understanding the IEP document, and go through it to make sure that you have an understanding of what is going on with your child's IEP, and that you as a parent understand it, and you as a parent can be an effective monitor of what's happening. When your child comes home from school, you want to know what's going on. They have a good day? Do they learn something? Do people show up? Sometimes parents find out, you know, somebody's been out 2 weeks, you know, sick from school because of some virus or something like that, you know, and so communication, I think, is what I'm saying, which is a two-way street, is the watchword.
And this leads into this question, Allie, which we received before tonight. What happens when my child has a 504 since third grade, intervention since kindergarten, and there's still no progress? They've just requested a PPT. So how should they handle that conversation with the district?
That's a good question. There's many ways to handle it. The first idea that comes to my mind is, how do we know that no progress has been made? And I think that's the first thing we have to do is document, document, document. That's what I tell my clients. You may, as a parent, feel no progress has been made, but the school wants empirical data, or should have empirical data. And so before you enter into a PPT or any other meeting with the teachers or the school administration, you should really take a look at the data that supports the no progress. Now, what data is there? Well, you have the IEP reporting sheets that Connecticut puts out. And I know from other families, and being a prior school administrator, those don't tell you that much. However, if you dig down deep into what the criteria is, you can ask the school or the specific teachers to evidence why your child has been rated an S for satisfactory. What is the data? If the child has been rated an N for needs improvement, ask, what is the data? And so you start gaining information that way by going to the school. Also, Portfolios. What papers is your child bringing home to evidence the fact that you're feeling that no progress has been made? Writing samples, math sheets, whatever it is, grades. If your child is a middle school or high school, you can probably go online and look at the grades. So there's many formats for data collection. So where do you go from there? If you have evidence, or even if you're feeling that your child is not making progress, then the first thing would be directly contact the teachers. That's your first step. Direct contact with the teachers, communication is essential. You could ask for team meetings rather than to start with the PPT. A team meeting with all the teachers in place serves as a really good platform for you to really understand what the school is doing and maybe what the school is not doing. If you're organizing a team meeting, I advise my clients to establish an agenda for the team meeting. So you know what exactly you're going to be covering and you have some control over what that agenda looks like, and make sure that you hit the understandings that you want to be brought out. Then probably the last option right now, after the team meeting would be to go to a PPT, because at the PPT, you can make changes in the child's IEP. The changes would be aligned to the progress that's not being made. So if your child, let's say, is not making progress in reading, specifically reading comprehension, let's say, then you need to go to that PPT, increase service time, look at the program that's being used, and possibly do another evaluation, whether it's within the school or outside of the school. That's what the PPT will have to make a decision on. So those are the steps, the data collection, team meetings, PPTs. Those are the steps that I feel will probably be the most important for you to be able to look at what is going on and then to be able to assess progress that way.
Yeah, and I would say do a deep dive. So with regard to reading, for example, if you feel your child is struggling reading, well, which aspect of reading? Is it the decoding? Is it the comprehension? Is it the fluency? Is it the accuracy? Is it all of those things above? And you can ask for benchmark testing to take place. So if you know your child is not reading at grade point level, you can actually do certain tests and diagnostics to find out, well, what grade level is your child functioning and reading at? And they might be functioning at 2 different levels. They might be able to decode at a much higher level than their ability to comprehend. So it is important to do a deep dive with some of this information you're presented with too, and don't be afraid to ask for more information from the district, and then to put it together as a timeline almost, so that you can see the chronological order at which your child maybe made progress at some point when they began to plateau, some of maybe the factors that affected the plateau or regression. So track it as a timeline chronologically, and that's easier for you to then start pinpointing things and showing the district at what point you started to notice regression, so that you can go back and address when it started to happen and then show the documentation from that point. It might be a bit tedious, but it is worth doing timelines for some of these pieces of information that you acquire as a parent. I've always found that to be quite helpful, and to understand the grade level that your child is functioning at, because remember, the districts are hopefully going to try and reduce that gap between your child and a neurotypical child within that grade. So it's important to know where your child is within that expected grade level of performance.
I just want to go back slightly. Somebody asked about the CRP. That's a federal mandate. In Connecticut, we call it a complaint resolution procedure, but every state Department of Education is supposed to have an investigatory function under the federal IDEA regulations. The IDEA is the Individuals with Disabilities Act. So whoever asked that, your state's Department of Education is supposed to have a complaint investigation function like we have here in Connecticut.
I was just going to add to that last question that Jane ended with about not making progress and where to go from there. One way to really impress the school and to show that you're organized and you know what you're talking about is to present a visual. I've done this for some clients, and I've coached my parents to do this as well. Do a chart, a visual of your child's progress from kindergarten, first grade, and on. So, you know, in all the testing areas that you see that that your child isn't making progress, because that visual goes very far in the way that the teen will interpret it. It's not just you saying something, it's them looking at something, and it gets kind of implanted up here. So I think that's a really advantageous way to present your situation in your case. So keep that in mind as well.
Absolutely. So this, Larry, this is a more legal question for you. How does a school or myself decide compensatory expenses? For example, services for a dyslexic child, if they were giving him 3rd through 7th grade?
Well, there are a couple of answers to that question. If we're talking about in the era of COVID-19, which is since March of 2020, because this question looks like goes back a little further, our state of Connecticut school recovery plan, which was published on May 24th, 2021, comes up with a process, a formula, and it sort of asks, it's like a flow chart. And it looks at 2 different eras. Did this happen during the spring of 2020 at the beginning of the COVID-19 health emergency, or did it occur last school year, the 2021? And the PPT is supposed to look at various ways, some of what Allie and Jane talked about, the progress monitoring, the data, because some children suffered disproportionately with the online learning, the virtual instructions. Some did okay. It wasn't great, but they did okay. And so if we're behind the 8 ball with what's called the denial of a free appropriate public education, services that were promised in the IEP that weren't delivered, you have the data that shows your child is not making meaningful educational progress, or worse, their skills are regressing, there is a school recovery plan and memo from our Connecticut Department of Education. The other answer is compensatory education is an equitable remedy that either a due process hearing officer or a federal court judge can award a family, but that involves litigation, a due process hearing or a lawsuit in federal court. So with some of the questions we've received, communications is very, very important, and communication is a door that swings in 2 directions, not 1. If you have concerns with your child's IEP, don't wait. If you have concerns with their progress, don't wait. Schedule an informal meeting. If necessary, request a PPT meeting. And as Allie just pointed out, you as family, the parents can track progress. If you have Dibbles scores, Ames Web scores, Smarter Balance scores, spelling tests, math tests, whatever objective and subjective information you have, you can chart that and say in 3rd grade, we're reading so many words per minute. Now we're in 5th grade, that number has gone down. The question is why? Maybe the words are harder. Maybe the child has other, demands on his or her time. Often there's an explanation. I always say, keep small problems small and don't let them become bushel basket size problems. So the smaller the problem, the easier you can get around it and solve it. And that requires ongoing collaboration, which sort of dovetails with one of our questions: how often should an IEP be updated? Some parents say, well, I can't update an IEP except once a year. That's not the law. The law is there has to be an annual review PPT meeting. If you feel the IEP, the IEP is not meeting your child's needs, don't wait. Request either an informal meeting with the teachers, the administrators, and maybe if there's a misunderstanding that can be established, lines of communication can be established. or request a PPT, a formal PPT meeting, and discuss your concerns, make requests for revisions of the IEP, get evaluations, whatever it is that's going to help you make an informed decision as a parent, if the question and concerns are coming from the parents.
Well, just one thing, I mean, the IEP document, the individual educational plan is not a static document. It's supposed to grow and move with the child as the child hopefully makes progress. So the goals and objectives and the supports in terms of the scaffolding level should change as the child makes progress, hopefully mastery, and then you move on to the next goal and objective. So the document, the IEP document, should not remain static in its composition in terms of the goals and objectives and the prompt levels and all those nuances. So if that is happening, then I would be concerned that there is no progress being made, because if a child is making progress, there would be slightly different goals and objectives. There'd be less need for certain levels of support built within it. So I would be concerned if I was not having the district review, revise and edit goals and objectives as we were going through the school year to reflect, hopefully, progress that my child was making.
We had a question in the chat about independent evaluations, and this also dovetails with the CRP. The question involved a request for a publicly funded independent evaluation back in July. The school retained an attorney. They haven't done anything. The school districts with a request for an independent evaluation have to file for a due process hearing promptly if they're denying the request. If they're granting the request, then you will select the evaluator and the school district will pay for that evaluation per the IEP policy or criteria of the school district. But in this case, here we are in the middle of October, and the school has not commenced a due process hearing within a reasonable period of time, which is usually about 30 days, maybe more or less. You could file a complaint with the State Department of Education and ask them to investigate and order, as part of the relief, a publicly funded independent evaluation. So that's my response to the parent who posted that question. And then the next one is, what does PPT mean? Pupil Planning Team Meeting.
So this is another question we received before this evening. I know we're getting an awful lot of questions tonight. I do regret that I don't think we're going to be able to get through to all of them, as we had a sizable number before the presentation, and we're still receiving a lot now as we're going through. And I'm conscious that 8 o'clock is looming, but let's try and get through a few more of these. So one quick question was, when my child graduates from high school to transition program, does the IEP turn into a 504?
So
you want to handle that?
Well, I'll start, Larry, and then you can probably finish. The easy answer is no. Okay, there is no 504 or no IEP, special ed, after graduation from high school. But as parents, and your child actually reaches, as you know, the legal age, at the legal age of 18, your child becomes his own or her own guardian. So at the age of 18, you don't necessarily have to look at your child graduating. The school is technically responsible for your child through 21 if he or she has an IEP, not with a 504. So at the, let's say that your child is a senior, and at the end of the school year, you don't feel that your daughter or your son is ready to go on to college, postgraduate years, because he or she has not really maintained or accessed the transition goals that were on the IEP. So that's one way that you can certainly access services and stay within the framework of high school. You do not have to accept the diploma. So even though your child has finished or completed all of the credits, academic credits, you don't necessarily need to accept that diploma if you feel that he or she has not accessed, as I said, or achieved his goals in transition. The way you would want to get accommodations after high school and after you accepted the diploma is making sure that your son or daughter schedules time with the resource officer or people in charge of in-house, what we call resource centers in postgraduate institutions like colleges, universities, and so forth. We have in place, most colleges, and I know state universities, have resource centers that your child has to really advocate for himself and go to the resource center to explain what accommodations he or she had during high school. And then they have an interview together to see which accommodations would benefit your student. So the accommodations don't necessarily follow from high school to college or any postgraduate institution, but knowing what those high school accommodations are and taking the accommodation form with you to any postgraduate institution will help the agency involved and your child to collaborate together to really agree on accommodations that would be necessary in postgraduate work. So the answer is no, but there are definitely ways to get accommodations in colleges, university, trade schools, and so forth.
Just a technical correction, the age of eligibility in Connecticut is now 22. The State Department of Education lost a lawsuit that challenged the age 21. It's now age 22. But the important thing is the planning process. And the planning process for children with autism starts at age 14 in Connecticut, age 15 for all other disability categories. And these are for students with IEPs. And that leads you to what Allie was talking about. Sometimes you graduate in 4 years with a regular high school diploma. And at that point in time, the school district is no longer responsible for your education. And sometimes students need a year or 2 or 3 or 4 of services beyond the traditional 4 years of high school. Once you go off to college, as Allie pointed out, most students are 18 and they are considered legally to be an adult. The colleges and universities do not want to talk to the parents. They want to talk to their students who are now young adults. And that's why having a strong sense of self-advocacy skills, understanding your strengths and weaknesses, understanding the accommodations section in the IEP, or if you have a 504 plan, which would have accommodations, how those would be beneficial in a college setting. There are no IEPs in college. There are accommodations under the Americans with Disabilities Act or Section 504. Both of them talk about reasonable accommodations, reasonable modifications, but they don't happen automatically. They only happen if the student himself, herself, self-advocates, contacts whatever the office that serves students with disabilities, develops the plan of accommodations, make sure that everybody involved, the professors, the dormitory, the cafeteria, wherever the accommodations are going to be applicable, are involved with the process. Sometimes we have people with medical issues that are accommodated. Sometimes there are academic issues that are accommodated. Sometimes there are food issues that are accommodated. It's sort of how high is up. There's no end in sight. And so you have a 504 plan when you have a recognized disability that's called a physical or mental impairment that affects a major life activity. And that could be thinking, concentration, walking, seeing, hearing, breathing. It's an extensive list. And whether it's in a public school setting or a college setting, you discuss a plan of reasonable accommodations, time extension, alternate test settings. You get to use technology where everybody has to do it manually. You get to use the calculator as opposed, or a computer, and everybody else without an accommodation doesn't. Or you have sometimes dormitory accommodations, are part of an accommodations plan. Class schedules, taking a reduced class load. There's no one size fits all approach to accommodations, either in a public school setting or a college setting. It's supposed to be individualized based upon the student's unique needs.
Just to carry on from this, one other question we received relating to opportunities after high school for those individuals that are not interested in further education for whatever reason, whether it's their circumstance or their decision or choice. There are other organizations locally and within the state that do a good job at help supporting that transition process into the community and into places of employment or internships and so on. So organizations such as Ableist and STAR are two such avenues that you can pursue, and that mapping process can start fairly early on with those organizations in play to help support your young adult and find out what their needs and what their interests are, so you can find meaningful employment or meaningful opportunities within the community that they might wish to explore, and you can explore with them. So it's not just about further education for some individuals, it's also about participation within the community and meaningful employment, and there's definitely organizations out there that can help you do that. I think Winston Prep also has a transitional program, and some of the other private schools do have transitional programs too. But even if you haven't graduated or attended that school, I think you can still have potential access to participating in that transitional program that they have as well. So just bear in mind that there are different options depending upon what the young adult is interested in, and together you work with a team of professionals that can help guide you through that process.
And sort of dovetailing with that, a parent asked about what information should I receive about my child who's a senior. The answer is everything. With a public school, it's different. You have access rights to public school information that you may not have the same access rights in the college setting. And whether a student should graduate is a PPT discussion. I've had many situations where students go to what's called a social graduation. They want to go to all the senior year activities, the prom, the dances, the field trips. But at the end of the school year, they go to the graduation without receiving a diploma because the expectation is they're going to continue on with their transition programming to further their education, employment, and independent living skills if necessary. So these are things that should be done out in the open with discussions, full disclosure, what you want, if your child is close to 18, what he or she wants, and certainly coming up with a plan, especially the transition plan, which I might add, there are resources on the State Department of Education website on transition planning. There's a directory of organizations in Connecticut that provide transition services and training. And there's a recent publication on the U.S. Department of Education on transition planning as well.
Laura,
So
I just want to add just one quick thing to that. I strongly recommend and suggest, if you have a complex learner as a child at a PPT, and I would say probably 10th, 11th grade, ask for a transition assessment. Larry just mentioned resources that the state has, but a really comprehensive transition assessment will detail all of the skills your child needs to be successful as a young adult after high school. And so this data, again, really drives the IEP. What information do you need for your child to make sure that your child is ready to graduate? And then also will detail some of the accommodations that you would want your child to have for postgraduate years. So a transition assessment is really important, as I said, especially if your child has many levels of areas of deficit or is a complex student in several areas. Many districts have their own in-house transition coordinators that do an evaluation, and we're very fortunate in Connecticut. We have some very good outside private resources as well. Thank you.
So there's one question here as we're getting close to the end in terms of time. What happens to an IEP when a student is suspended or expelled from a school?
I'm sorry, I didn't get the last part. What was it?
What happens to an IEP if a student is suspended or expelled from a school?
Well, it depends on the age. If they're over 16, which is a line of demarcation, and under 16, if they're under 16 and they're suspended that's up to 10 school days, not much happens. It's when we get to the 11th day, that becomes the expulsion. And under state law, if they're child's under 16, they're absolutely entitled to continue their education. It may be in an alternate setting, but they get the services in their IEP. If they're between 16 and 18, it depends if the student wants to continue with services or not. Over age 18, the school district is not required to provide services if they're expelled. Now, before you get to the expulsion for students with IEPs, there's a special set of rules that deal with school discipline of students with IEPs. And the long and the short of it is it'll end up in a manifestation determination PPT meeting. If the child's manifestation determination PPT meeting determines that whatever the child was accused of doing that caused the suspension and the recommendation for the expulsion was directly or substantially related to their disability, then the child should be helped. The IE should be revisited, services, evaluations, whatever is going to help the child receive the free appropriate public education. The flip side of that coin, if the manifestation determination PPT determines that whatever the child is accused of doing was not related to his or her disability, then that child can be disciplined just like any other child without an IEP. Parents can request a due process hearing to challenge the outcome of the manifestation determination PPT meeting. That doesn't mean the expulsion hearing will be stayed unless there's an agreement between the family and the school district. Often in that contentious type of situation, it's advisable to have an attorney because you'll have, in effect, three things going on at once: a recommendation for an expulsion, a manifestation determination PPT meeting, and the possibility of requesting a due process hearing to challenge the outcome of the manifestation PPT meeting. So the child is under 16 should still get the services in the IEP. Over 18, no. 16 to 18, maybe.
So there's lots of questions here about how to get out of district placements and what is the best course of action to get an out of district placement. There's lots of different ways to do this in the experience that I've had. Ali and Lawrence, can you share some of your experiences in providing students with out of district placements?
Well, the simple answer, if the parent is going to pay for it, then that's how the out of district placement will occur. If the parents are seeking an out of district placement through the PPT process, in other words, they want the school district to make the out of district placement, one has to establish there's a denial of a free appropriate public education. From my perspective, which is not universal, I'm an attorney and this is how I approach my cases. I usually have an evaluation report supporting the parent's request. There's a denial of a free appropriate public education. Here's the reasons why, and my professional recommendations as a psychiatrist, a psychologist, or medical professional is that my patient or the person I just evaluated needs a therapeutic placement, a school for children with autism, a school for children with learning disabilities in order to receive that free appropriate public education. You bring that information to the table at a PPT meeting, maybe the school will agree, maybe the school will disagree, but that's how the process starts. With a request that's supported by not only the parents' wisdom and experience about their child, but somebody who is a medical professional, psychiatrist, psychologist, pediatrician, other sources of information. And then if you have a school in mind, the other side of the coin is an acceptance letter. It's the one thing I want, and it's the other thing finding the school. A lot of schools, because of COVID-19 health emergency, cut back on their enrollment. So there are more applicants than there are seats. So you have to, and you have to be flexible. Sometimes the school you want may not have any openings.
And just bear in mind, there is a question here that somebody submitted saying, my child still struggles in school, although she has an out-of-district placement. What more can be done? The out-of-district placement isn't always the silver bullet. And you have to be mindful that there's lots of different types of schools that your child can be outplaced to. So it's finding the right educational environment to meet your child's needs. And just because you hear from one family that one school is doing marvels with their child doesn't necessarily mean it's going to be the right educational environment for your child. So the out-of-district placement doesn't always provide parents with the education, the appropriate education they hoped it would provide their child with. Allie, do you have any other comments on that?
I mean, I completely agree with you, Jane. An out-of-district placement is not always a panacea, and it's not one size fits all. So, the first thing I would look at is, why do you feel that the school is not meeting your child's needs? What areas specifically? If your child, let's just say, has a reading difficulty, whether it's dyslexia or a specific learning disability in reading, that particular private school may not specialize in specialized learning strategies for reading. Maybe it's a school that is more of a therapeutic school and focuses more on behavior. I don't know, but certainly look at what the school is really focusing on and match that to your child's needs. The state of Connecticut has a list on their website of approved special ed schools. I would certainly take a look at that, and certainly there are many other private schools, but certainly I think that it's the right school for the right child, and it's very uniquely, very uniquely decided upon. It's not just, oh yeah, I got an out of school district placement. It's very specific to your child's unique needs.
And I'll just add one brief comment. If this is a PPT placement at an approved private special education school, that school effectively becomes an extension of the public school, because they're delivering, or they're supposed to be delivering, the IEP that was developed at a PPT meeting with the parents, the public school, and representatives from the private school. In other words, whether it's a public school or a private school, if there's a PPT placement at a private school, it should provide a free, appropriate public education. I see we have a question that was in the chat about a child who has selective mutism, and is making very little progress. Well, that's where that free, appropriate public education is there. My limited experience with selective mutism, it's a source of anxiety that's causing selective mutism that may or may not be accurate in this person's situation. I would have a comprehensive evaluation, updated evaluation, because the transition from elementary school to middle school is going to be much different. You're going to have a lot more transitions, more teachers, possibly a larger school. And you want to make sure that the sending school, the elementary school, and the receiving school, the middle school, are on the same page as to how to address the child's needs. So we'll have a better experience rather than, a lack of or little progress.
I think there's certain explicit therapeutic practices as well for that kind of diagnosis. So just maybe do a little bit of research and see what recommendations the district makes to support your child that has selective mutism as well, because it can be quite a complicated disorder.
Just quickly to augment that, I've had experience with cases on selective mutism. It is very unique. It's not widespread. So I definitely agree that you need to research it, but also you need to get an evaluation by an expert in the field. Not every school psychologist is an expert in selective mutism, and even clinical psychologists, many of them, that's not their chosen area of expertise. So research it carefully. We do have in the state of Connecticut, I know of several experts in the field. They're not easy to come by, but you do need a comprehensive evaluation through a specialist in that field.
Mm-hmm.
We had a question about observations in classrooms, and I guess that assumes, I assume it's a parent who wants to observe their child in the classroom. Have either of you run into obstacles or solutions to that request?
Well, definitely you have the right to observe your child in the classroom. I know administrators will use the argument, oh, there's confidentiality issues and so forth. But as a parent, you have a right not only to observe, but it's your responsibility to be a partner in your child's education, to be a participant, to be involved. You have to be informed. And in order to do that, you may need to visit the classroom. Now with COVID, there are certain restrictions, and that is definitely a district by district decision. You may be able to observe remotely, but certainly, you'd have to check with your district administration for that. But the idea of an observation is something that you are able to do, and you have a right to do that. As far as a designee in place of you, like a private clinical psychologist, that's a different story. Many school districts, I shouldn't say many, but there are several school districts that I am aware of that do have limitations with outside providers coming in. Again, that is a district to district process and procedure. So you would have to check with your administration. But as a parent, you do have the right.
Yeah, and just bear in mind that as a parent, if your child sees you observing them in their educational environment, they might behave differently. So you might not necessarily get the information you're expecting to by observing them, because your presence might interfere with their typical behavior or their typical ability to attend and focus to task. So there are circumstances, and certain schools have different rooms set up that you can observe through different movement systems, or in different scenarios. So just entertain that idea as well before you go in to observe, because you don't want to skew what it is that you're trying to suggest or find out.
We had a quick question where transportation is too long and the parent wants to know if they can provide transportation and be reimbursed. The answer is yes. If the school transportation is too long, not appropriate, and you want to provide your own transportation, there is a provision in our state regulations that allow you as the parent and the school to negotiate that kind of arrangement. Usually the school district will use the IRS business mileage rate, which right now today is 56 cents per mile. It might go up on January 1st, but right now it's 56 cents per mile. And if you and the school district reach that agreement, and you'll send in monthly mileage requests, quarterly, whatever you and the school district negotiate, but that is an option.
So one question here as well we had was how to get related services like music and art therapy on an IEP. I've done IEPs where I've been successful in getting aquatic therapy because we've shown that through the additional PT and OT support and therapeutic input that has for the child, it's enabled them to have greater access to the curriculum when in the school environment. But with regard to music and art therapy, have either of you had success getting that incorporated into an IEP?
Yes, I have had success. It's not widespread. You really have to go down the path of looking at the IEP and what your child's needs are. For example, if it is documented on the IEP and you have a documented evidence to show that your child needs calming strategies, specifically in music, let's say, and the school cannot provide for those needs because they do not have a music teacher able to do that, then that would be that would be a rationale for having somebody come in to, to provide music therapy. But again, your child's services need to be aligned to the goals and objectives and to his or her needs. And the needs have to be documented. There is a difference between what you want for your child and what your child needs and requires. So you have, as a parent, you have the obligation to demonstrate to the team, and this would be at a PPT, demonstrate the need in the requirement that your child cannot make adequate progress in his or her learning without the music therapy. I've had horseback therapy, put into IEPs, but they are very unique situations, and in each situation is different. It also helps to get an outside therapist letters of recommendation that will say, so-and-so needs music therapy and state the reason for it. So it's not just you as a parent or a guardian stating this, it's a professional that has worked with your child to be able to document the rationale for these related services.
And that's an excellent point, whether it's art therapy, music therapy, or anything else. Parents have expertise and wisdom about their child, but when that expertise and wisdom is buttressed by an outside evaluation report, validating the parents' concerns, documenting how this service would be beneficial to providing a free, appropriate public education, or in one person, the paraprofessional was provided and now my child is below grade level. Whatever information you have as a parent, you need to bring it to the attention to the school district. Your measures of progress, the school district's measures of progress may be a little different, but they should all end up at the same place, and that the child knows more this year compared to last year, or knew more today than yesterday. And the gaps, the identified gaps, are starting to narrow. You're able to see measurable progress, meaningful progress, generalization of skills to other settings besides school. And, this is what special ed is supposed to be about. It's not a place. It's supposed to be a service that is designed to help your child succeed. It's supposed to be a bridge to connect the dots to move forward. And spirited advocacy on the part of parents each and every day is essential for the success of each child, because on a day-to-day basis, nobody knows your child better than you do. The teachers may know a lot about your child, and they do. Evaluators may know a lot about your child, and they do, but so do you as parents.
I was going to say we've had a tremendous number of questions tonight.
I was going to say that we are very close to wrapping up. We have too many questions and too little time. So I wanted to thank Allie and those who've participated this evening for joining us. We will continue these conversations with issues of involving special education. We will continue to have a watchful eye on special education issues, the law, latest memos, policies coming out. Our next Zoom webinar is scheduled for November 16th at 7 p.m. We're going to have our guest, Dr. Robert Kruger, who is a board certified psychologist. And the general topic is looking at evaluations. We've had a couple of questions this evening about evaluations. If you could join us on November 16th, have some more questions for Dr. Kruger to address. We'll look at the evaluation process, how evaluations are relevant to the PPT meeting process, the different types of testing that's out there, how to measure progress, starting with a baseline, future planning. Somebody had asked about the independent evaluation. We'll have a little more specific information on the independent evaluation. And if there are any special considerations today that are still relevant to completing evaluations in this era of COVID-19. Some evaluators went to online evaluations, some continued in-person evaluations. So sometimes there are very unique circumstances that will affect either school district or private evaluations. So I want to thank Jane, Allie Grafman for your insights and collaborative efforts and thoughts this evening. I also want to give a shout out to my own daughter, Rachel, who's put all this together. So those who have received her emails, and one question was, will I get a recording? The answer is yes. If you've signed up for the webinar, a recording will be made available. So I want to thank her for her efforts. We welcome your questions. Remember, we'll be back here on November 16th, so send us questions ahead of time. To register and learn more about future events, check out our Facebook page, the website, the Jewish Community Center and Facebook page. I want to thank you for tuning in. Stay well and stay connected. And I'd like Jane and Allie to offer their concluding remarks.
I would just like to thank everybody for coming tonight. We had a tremendous amount of interest, and I think it'd be nice to have Allie back again to answer some more of these questions, because we really did not get through to all of them. We ran out of time. And just to remind everybody as well to check out the JumpStar's Facebook page. It's an opportunity for you to come and enjoy free social, recreational, as well as these educational platforms. But the social recreational is now in person, and we have some great events coming up towards the end of this year and scheduled for next year. It's an opportunity for you to connect with other parents and caregivers that might be at the same place in your journey or a bit further down the line. And it's really important to be part of a bigger community and to share and connect and relate and have common experiences as well. So please check out JumpStars, and I look forward to seeing you again soon. And thank you, Allie, for joining us tonight. It's been extremely informative.
Well, thank you for inviting me, and thank you to all the participants. Your questions were excellent. In fact, as we said, we had too many, but they were excellent, and it made me really think and explore some of my own inquiries. So that was actually a very good mind exercise for myself. Mm-hmm. I just want to say that I love what I do, and my biggest pleasure is to coach parents to become the best advocate for their own child. And that's when I know that I have done a really good job, when you as parents can become your own advocate. And that's all about attending roundtables like this, going on different, research engines, websites, visiting the state of Connecticut or whatever state you're in, their websites. So all this information comes together so you can help your child. And that's what makes this so wonderful. Thank you again for joining us. And thank you, Rachel, for all your hard work behind the scenes.
Yeah, thank you.
Thank you.
Good night.
Good night.